to the British Institute of Radiology. Today is the 23rd of September, and it's a special day because today we have our first, not seminar, but webinar, if that's the way you pronounce it. And today's topic is the essential guide to medical imaging schemes and developments. It's a very important subject because if we don't procure, install and commission imaging equipment correctly, well then you're in big trouble. But today we have assembled a number of distinguished experts from the imaging community, representing various aspects of the Department of Health through to different companies involved in the process and radiographers. So I hope you enjoy this seminar, and I'm going to hand over to my colleague Chell from the Department of Health.
Thank you. Good morning. Hello, I'm Chell, and I'm the Policy Manager for Ionising Radiation in the Department of Health. First, I would like to thank Stuart Whitley for inviting me to speak and to congratulate the BIR for their innovative approach by filming today's programme in order to reach out to a wider audience by means of their website. My role within the Department of Health does not really cover the issues addressed today, but I do have a diagnostic imaging background as an X-ray engineer with Siemens for many years and as a device specialist with the former Medical Devices Agency, now MHRA. I've chosen to give you an overview of policy and legislation to help give a general overview, and my esteemed colleague Nigel Tomlinson will give you a more detailed view on relevant guidance after my talk. My current role involves the protection of humans from the effects of ionising radiation. And I do have contact with radiology departments, but it is more to do with the regulation of medical exposures rather than the commissioning of X-ray rooms or device aspects. I must add that this presentation is for education purposes only and does not reflect any official position of the Department of Health. I thought it would be a good idea to start off by explaining that policy is a plan of action adopted by government, and it is pursued or adopted and taken forward by policy officials such as myself, and my job is to identify gaps or flaws in policy and to resolve it, which can be by many means of action. We consult with the devolved administrations and professional bodies in order to make sure we are tackling the matter in an appropriate way. So how is policy implemented? It can take many forms by statutory instruments such as the Ionising Radiation Medical Exposure Regulations. It can be by guidance, which is about duty of care. We now have working together documents, which is a more modern version of memorandums of understanding, or we delegate the action to other government bodies like Environment Agency or enforcement authorities. So what is regulation? It is defined as the act or process of regulating. It is a rule, principle or condition that governs procedure or behaviour. Regulation does not necessarily mean it is enforceable by law. Guidance is a form of regulating. Guidance in modern government is agreed by consent by the relevant experts along with the responsible government department. Regulations always come in the form of a statutory instrument within an act. The wiring regulations sort of break the Trades Description Act because it is actually guidance. I appreciate it is a standard, but in essence it is treated as guidance in a court of law. The name breaks my rule number 1. A tin should always contain what it says on the tin's label. Guidance does not have to be heeded, but if a failure is proven in a court of law to be due to the latest relevant guidance not being followed, then blame can be attributed under a duty of care, unless the decision not to follow guidance can be demonstrated to be plausible. It is important to understand that guidance in this day and age can have varying degrees of legal weight. I would suggest that if you need to establish the legal position of guidance, you should seek advice from suitable legal advisors. Do not ask your fellow professionals, because I've found that there are significantly varying views on the status of guidance. Medical devices are regulated by law under the Medical Device Regulations in the UK by the Medicines and Healthcare Products Regulatory Agency, which is the UK regulator. Being a regulator means they enforce and hold UK policy responsibility for those particular regulations. Domestic buildings are subject to the building regulations enforced by local authorities. This can be interpreted in different ways by the local enforcement offices. They can choose not to inspect each particular stage of the building. The power electrical installation should heed the wiring regulations guidance. The only enforcement can be through the building regulations by the local authority. The electrical installation of medical devices in medical locations is now regulated by the guidance called MEGAN, which is the Medical Electrical Installation Guidance Notes, which is hosted by the Medicines and Healthcare Products Regulatory Agency. MEGAN has the same status as wiring regulations. The NHS can insist as part of a medical device contract that the project is installed according to MEGAN. I understand Scotland and Wales do this, and I understand that in Wales they employ someone to check the installations to ensure conformity to MEGAN is achieved, which is exactly how it should be. Naturally, in England, the medical device suppliers ensure their devices are installed to conform to MEGAN, but it is up to purchasers to ensure that this is double checked. I work in the field of radiation protection, and I thought I would explain justification, which is a globally agreed principle. The exposure of each patient to an intentional medical exposure needs to be justified by a referrer, and then finally by a practitioner. These are definitions within the Ionising Radiation Medical Exposure Regulations, and I hold the policy lead for these regulations for the UK, and they are enforced by an enforcement authority in each devolved administration. In England, that is the Care Quality Commission. Government policy can be delivered in many ways. The policy that we've agreed with the Care Quality Commission over enforcement of the medical exposure regulation, for example, is one of lessons learned rather than prosecution. This policy means reporting is improved so repeat mistakes can be reduced or prevented through feedback. The current radiation protection directives are being revised into one, which means a lot of policy work for all government departments. This will mean UK regulations will need to be reviewed in the future. The new government. Another example of policy of the new government is that officials cannot now just introduce regulations because an old regulation is repealed. This new policy is called better regulation and in general encourages more guidance. Deregulation is the wrong term. Better regulation aims to reduce the burden on business, and any new regulation must not cost business any more money. This is demonstrated by policy leads performing an impact assessment. I led the policy on the new medical exposure amendment regulations introduced this summer, and the effects on business had to be looked into. Now, do you remember my original definition at the beginning of the presentation about regulation? Regulation can be in the form of guidance agreed by professionals. One such example is the regulation of cosmetic lasers. This practice is regulated by the guidance produced by the cosmetic laser industry. This was because, even though experts deemed it to be a hazard, there was not any evidence of harm caused by the practice. Therefore, the Department of Health chose to promote regulation by professional guidance. So, in summary, please don't try to dodge guidance. It isn't statutory, we know, but avoiding it may come back to bite you when things go wrong. Quality of installations is devolved to the NHS now and the independent sector, apart from the quality assurance of the X-ray equipment. The regulation that covers the installation of equipment used for medical exposure is the Ionising Radiations Regulations 1999, which impose a duty on the employer or purchaser of the equipment to ensure it is fully tested, but this only covers the radiation protection aspects. And finally, it is important for purchasers to state guidance requirements that need to be met in their purchase contracts, i.e. contractually, and don't forget to seek legal advice if in doubt about guidance. I hope you found this presentation useful. Thank you very much.